Good afternoon, good evening to all who are joining today in the Khaitan and Company and Compat joint webinar along with Indian Institute of Management Ahmedabad. It's a great pleasure for me to introduce the panel before we start the webinar formally. We have got excellent co-panelists today in the webinar, and I'm requesting all the attendees, if they have got any questions, they can do so on the chat box. Time permitting, we'll be answering as may be required by the participants asking the question to which amongst the panelists, and that of course would be at the end of the webinar. So to start with, let me introduce Mr. Dhanendra Kumar. As all of us know, he does not require any introduction as such, but still, as a formality, we must do that. Mr. Kumar, before joining the CCI as the first chairperson of the Indian Competition Commission in February of 2009, he was also the executive director of the World Bank. And then, being an IAS officer, he also held several positions in the government of India, including secretaries to various ministries, including the Ministry of Defense, Defense Production. He is an IAS officer of the Haryana cadre, and he has been instrumental in bringing about many changes in the industrial landscape of Haryana state. So we are very happy to have Mr. Dhanendra Kumar as one of our pioneers of the Competition Act who would be helping us to share our thoughts and our experiences in the next 1.5 hours. Then comes our professor from the prestigious Indian Institute of Ahmedabad, Indian Institute of Management Ahmedabad, Dr. Vishwanath Pingali. He's, of course, as of now, a professor of economics, but he had his postgraduate degree from Indian Statistical Institute, Calcutta. Thereafter, he went on into the US to complete his PhD on industrial economics from the new Western universities. And his uh, specialization of economics actually dovetails exceedingly well with the competition law, because competition law is a mixture of competition law and competition economics. And the economic specialization, what Dr. Vishwanath Pingali has had the greatest opportunity to have done it in the US, dovetails extremely well with the Competition Act of India. And that naturally gives us a wonderful opportunities to share his thoughts with all of us, the practicing lawyers and the first chairperson of the CCI. Then I'm introducing Pranjal Pratik, my colleague in the competition team of Khaitan and Company. He's a partner. He is a partner of a full service top tier Indian law firm, which has a exclusive vertical on competition practice, and Pranjal does that. He is actually leading his clients in antitrust matters, that is relating to cartels, bid riggings, abuse of dominance, exclusive agreements, merger control, and also he has been instrumental in helping one of our senior partners, Mr. Hegriv Khaitan, while he was also a member of the Competition Law Digital Committee of the Ministry of Corporate Affairs. So he had first-hand knowledge as to how the digital competition bill has panned out in this country, and he will be giving a first-hand view of during the course of our webinar. I am Manas Chaudhary. I am a colleague of Pranjal. I am a partner in competition law. I also, before joining Khaitan and Company, of course, I've completed 15 years in Khaitan and Company of 1st of December this year. So before that, I was, of course, part of the Indian Competition Commission, that is the CCI, and also I was in the MRTP Commission. So I have had the great fortune of having seen the transition between the old and the new regime, and I'll try to touch upon a few interesting points as to how the transition happened in India. With that, I stop here and I request Dr. Vishwanath Pingali, who is our moderator of this webinar today, to start the formal session as a moderator of this webinar. Over to you, Vishi.
Good afternoon, everyone. I hope I'm audible and I'm clear. Can one of the panelists confirm, please, that I'm audible and I'm clear completely? Please excuse if my voice is sounding a little croaky. I taught 3.5 hours constantly in the morning, so therefore, if my voice is a little dull, my apologies upfront. Manas and Pranjal, thank you very much for inviting me and making me the moderator of this session. The moderator's job involves directing the discussion and also correcting here and there. So therefore, I expect my red pen to do a lot of talking today as well, just as it does always in the exams that I grade of my students here at IMA. So I'm really looking forward to, because this is something that I am dearly interested in, and I've been working a lot. How do digital markets dovetail with the Indian economy in general, and what are the various ways in which you understand the competition in digital markets. Are those platforms really competing with each other? Are they exclusive? Is there single homing? Is there multi homing? Or if you start talking about it, you open a full Pandora's box, and trust me, I can spend an entire 1.5 hours just talking myself. But in the presence of such illustrious company that I have, both from practice as well as from the people who've been on the upper echelons of policy making, it's only fair that I actually invite them into the conversation here and request for their views. Of course, you'll expect me to interject here and there, but I think I'd like to start off by talking to Dhanendra Kumar ji. Dhanendra ji, you've been the first chairperson of CCI. That's quite a bit of an achievement. I mean, you had a previous regime, the previous regime translated to competition regime that we have currently, and you were probably one of the torchbearers of this particular change that we're talking about. Therefore, I'd like to ask your views in terms of how you see this transition. I would like to ask your views on how you started this journey with Competition Commission. Along with India, there are other jurisdictions also that have started this competition law and competition related issues. How do you think, the journey that we've covered and the journey they've covered, how do you compare? Maybe if you could even shed light on how various international bodies have come together to help us, or how we've influenced international bodies. If you could give us, start us off in general on the evolution of what you see as Competition Commission that it is today. That would be a good starting point for the discussion, sir.
Thank you, Dr. Vishwanath. Let me first of all mention that it's truly a privilege to work today on this prestigious panel. Manas and I have worked together in many areas, a very distinguished name, and so is Pranjal. And Dr. Vishwanath is considered to be a highly respectable academic in this field. In response to your question, let me first of all mention that the day I joined, which was 28th, 29th February, and on that day when I joined, 28th, next day, this joining was reported in newspapers. I received a lot of phone calls from friends, many of whom asked, well, you got a new assignment. And by the way, what do you do? What is this competition commission? Do you conduct competitive examination? So that was the first time many of us in India had heard about it. So since you asked the journey, so from that point onwards till today, much water has flown under the bridge, and now there is a, I would say, almost complete awareness about competition commission, what it's supposed to do, what is its role, and what are the benefits, and so on. So that is one. And then people knew about MRTP. They asked me, it's a new avatar of MRTP. MRTP, of course, was a different cup of tea in the sense that they used to frown upon dominance and many other things. In this legislation, you don't take adverse view of any bigness. Of course, dominance, abuse of dominance is something which is frowned upon, and people very soon knew about it, that you can grow big with your technology, with your efficiency and so on as much as you can, but you should not abuse your dominance. Then we had to travel around a lot and educate people, do a lot of advocacy, and also tell them that the how competition commission can be of use to them, both to consumers, to the small scale industry, and also to industry themselves. So the various benefits that it is meant for economic development of the country. If you look at the preamble, that the first thing, it is a tool for economic development of the country, and that remains true even for the digital competition law, which is only a part of the main competition law. Now, we have to ensure that the Competition Commission works in a manner that it helps promote, it helps in catalyzing competition, it helps in lowering the barriers, and also induct new technology. If we look at the preamble, it talks about to prevent practices having adverse effect on competition, to promote and sustain competition, to protect the interest of consumers, and to ensure freedom of trade. Now, through all these activities, it is possible to promote efficiency, both static and dynamic efficiency, and it is through this route that the economic development takes place. If we look at the achievement so far, since this is what you meant, the journey so far, Competition Commission in India has come a long way, and since its inception, it has reviewed about 1,250 antitrust cases and over 1,000 M&A cases, and I'm very happy to say that it has cleared most of the cases, 92% cases of antitrust types and almost 95 plus percent cases in the M&A space. So it has acquired a big reputation on the same table now as most of the well-established and advanced jurisdictions, whether in USA or UK. In the beginning, we organized training and capacity building with their help, and I'm very happy to say that our team in the CCI at that time, which was relatively new and raw, if I may say so, they have come up very well, and many of the judgments have been cited elsewhere. Most of them have been upheld in various courts, in high courts and Supreme Court and the appellate tribunals. So I would say that CCI has come up on its own now as a very mature jurisdiction, as a with this modern market-oriented approach. And in terms of the digital economy, there are many biggies like the Googles and Amazons and Microsofts and so on who have come up, and there are many issues on which we can touch upon later. But I would only like to say that the objective is, because it's economic development of the country, we have to make sure that the small scale industry, medium small scale industry, MSME, micro industry, and so on, they are not put to a disadvantage as a result of the advent of digitization, because now digitization is the rule of the game, and in most of the sectors, that is the common running theme. And in digitization, generally, there are certain characteristics, the winner takes all, the tipping of the market. Uh, so those are the kind of things which happen, and therefore the digital competition bill has come into place, which many of the other countries, including EU and USA and UK now, they formulated their own versions of competition law, but the digital competition law. But we have to make sure that the whatever version we decide to adopt for India is suitable for the characteristics, for the dynamics of the Indian economy, in order to promote, to push Indian economy to the level of Viksit Bharat that we have in mind in the next 2 decades or so, and that's what it is planned for. Thank you very much.
Thanks, Dhanendra ji. I think you gave a very interesting perspective. There is a pragmatism of law and there is an idealism of law. And when you're talking about pragmatism, the country's development should come in the forefront, and that's the benchmark for pragmatism of the law. And I think I really appreciate that particular thought. And I'm going to push you a little later on that very theme of development of the country at the forefront. There's a lot of literature that is coming out on how MSMEs take advantage of the digital market, but we can talk later. Manasa, let me bring you in into this discussion. You were one of those people who were very seriously involved in the transition. Matlab, you were a part of MRTP commission, and then you went into the competition commission. Then you moved on and you started your own. You've gotten into private practice regarding competition law. You advise clients, all the big corporates, small corporates, everyone on the competition law and the implications thereof. Maybe I can talk, I can ask you to come in and maybe talk a little bit about the transition that you saw across various regimes. The way I look at it is that there is an RTP, and then there is competition law, and now we're talking about digital, and then very soon we will talk about the next generation of digital, namely AI and everything else. So there has to be a thread that is linking across various regimes. And I think it's important that somebody who's worked through all these so far, at least, to be able to shed some light. So maybe I'll ask you to take a little bit, walk us through the journey here.
Thank you. I'll take a little more time because this particular topic, the transition between an old regime and a new regime in a democracy, which also had witnessed two very interesting milestones in between. One was the economic liberalization of 1991 and India becoming a member of the WTO in 1995. These are the two very important milestones which also give some kind of uh, linkages with the transition. So I'll just take a little more time than perhaps otherwise, this topic itself can be covered in 2 hours. The transition between MRTPC and CCI. So I'll be just making it brief, but it will be little more than the normal. So what is the answer to your question is MRTP Act 1969, which actually came into force in August of 1970. That means the enforcement began in 1970. So the journey has been initially, of course, very interesting. The first chairperson of the MRTPC was an economist, and subsequently, the judges have started becoming the chairperson of MRTPC, but the first chairperson was an economist. That's very interesting. And when we actually were fighting the Brahmdatt case before the Supreme Court, the question arose: can an adjudicating body be headed by an economist? That was the primary concern in the writ petition before the Supreme Court. So I'll come to that later, but I'm just giving you a heads up that the first chairperson of the MRTP Commission was an economist. So what happened from the time it came into being and in enforcing, the two limbs of the MRTP Act were primary. One was the restrictive trade practices, and subsequently, by way of an amendment, unfair trade practices were introduced. Both these limbs of the MRTP Acts gradually became deemed illegal, which in law means they are per se illegal, unlike the enforcement of the Competition Act, which is rule of reason based. So the first departure which the MRTP and the CCI is the restrictive trade practices, which of course include cartel kind of a conduct. Then also they have within that restrictive trade practices, they have the margin squeeze, they have all unfair trade practices of say disparaging and unfair advertisement. All of these were there part of the law, which nothing is foreign to anybody who is practicing antitrust law then in the world. And more or less, we have developed that MRTP Act from the UK. But the basic fundamental of the MRTP Act in terms of the Indian Constitution was the directive principles of the state policy, Article 39. If we read Article 39, Clause B, and if we read the preamble of the MRTP Act, it is actually a mirror image. So the whole concept of Article 39 is that the natural resources of the country shall not be distributed to the detriment of the consumer. MRTP Act actually revolved around that concept. And restrictive trade, and mind you, restrictive trade practices or unfair trade practices both were only to be looked into against private enterprises because the public sector enterprises were exempt from the application of MRTP Act. So the level playing field or competitive neutrality were really not an area of concern for the Indian government or the parliament. So it was all private enterprises who would be restricted from adopting restrictive trade practices, unfair trade practices. Subsequently, by way of an amendment, even compensation applications and interim leaves were added into the MRTP Act. Then comes 1991 economic liberalization, and with the merger control regime in the MRTP Act being almost defunct. Between 1970 and 1991, if I recall, there were only two cases of merger control, and both of them did not see the light of the day. The reason why it did not see the light of the day because Part 3 of the MRTP Act actually frowned upon any acquirer going over 25% of the share of the target will have to get the clearance from the Ministry of Corporate Affairs. Then it used to be called the Department of Company Affairs. So naturally, any company who would like to really acquire more than 25% of the share, because of this rigmarole of the law, they would never get a benefit of the merger control benefits as we get it in the current Competition
So
Act.
contestability was never considered.
Absolutely. with the economic liberalization came into being and MRTP Act after 1991 economic liberalization, there was an amendment. They did introduce the public sector undertakings to also be investigated under the MRTP Act, but it again did not see the light of the day. And then came the Raghavan Committee, which wanted to really have a overview of as to whether or not that MRTP Act should continue in the economic liberalized scenario, India signing the WTO, or should we really have a new law? The Raghavan Committee recommended that we should repeal the MRTP Act being lived its utility, outlived its utility, and we should have a new, fresh competition law which should be as modern as any other jurisdictions we have in this whole space of competition regime. Interestingly, if you see between 1960 and 1991, we had about 20-25 odd competition agencies across the world. Between 1991 and today, we have 135 competition agencies, and most of them are developing countries. This clearly shows that the impact of the WTO and the free trade also entails preservation of the domestic industry so as to ensure that the regulatory regimes are created within the country. And with one of the contentions of the Raghavan Committee that we should have a Competition Act. Competition Act, of course, was enacted, and on 13th of January 2003, it got the assent of the President, and the law came into the Statutes Book of India. However, immediately thereafter, in August of 2003 and subsequently in October of 2003, we had two very interesting writ petitions filed, one in Madras and one in Supreme Court. In both the writ petitions, the basic challenge was the structure of the Competition Commission should be identical to MRTP Commission, which primarily means it must be headed by a judicial member. So it became a contested hearing, and at the end of the hearing in January of 2005, the Supreme Court gave an interesting observation that while we appreciate that the competition agencies across the world is a specialized body with diversified professionals manning the commission, we do not disagree with the arguments of the Union of India. However, in order to mitigate the risk of a judicial member not being there and Supreme Court being the appellate authority for the final appeals, it would be better that we should have an appellate tribunal in between CCI and the Supreme Court that should be headed by a judicial member. Then the oversight of the Supreme Court would be on points of law only. So that actually brought about the amendment of 2007. And as Sir said that in 2009, February, Mr. Dhanendra Kumar was appointed, and soon thereafter, the other two members were appointed. And on 20th May of 2009, Section 3 and 4 of the Competition Act, that is anti-competitive agreement and abuse of dominance, were notified. And on 1st of June 2011, Section 5 and 6 were notified, which actually credit must go to Mr. Dhanendra Kumar, who was instrumental in bringing the merger control regime into the Competition Act in 2011 June. So this is a brief history of the two regime, but I would like to really add something which would be very interesting for the participants to listen. One is that in MRTP Act, we did not have any provision relating to imposing penalty against the delinquent contravener of the law. It simply had the cease and desist order. And also I was sharing with Pranjal yesterday that there is a very innocuous section 38 in the MRTP Act, which all the time litigators used to take advantage of, saying that my alleged contravention is in public interest. And that used to be called gateways. So section 38 was the gateway. Everyone would say that, well, even if I indulge into anti-competitive practice or restrictive trade practice or unfair trade practice, it was in public interest. So more often than not, section 37, which is the contravening provision, and that too only cease and desist order, was more often than not diluted because of section 38. So in nutshell, if we go back to the evolution of law under MRTP Act, we have clearly two judgments of the Supreme Court which we can definitely rely upon even today. One is 1977 Telco judgment, where the Supreme Court said that in a restrictive vertical restraints, if the party in the upstream is able to demonstrate that there was pro-competitive effects in an exclusivity arrangement, even that can be considered to be pro-competitive. So the Telco judgment even we can rely upon today. Similarly, there are, of course, a couple of other judgments. One is Mahindra and Mahindra judgment. One is Colgate-Palmolive judgment. These three judgments, we can really say that these are in the 35-year span of MRTP regime. These three judgments were the settled principles of law insofar as the Supreme Court is concerned. MRTP Act did not have the leniency provisions, did not have competition advocacy provision, did not have effects doctrine, that is cross-border antitrust issues impacting Indian market, our section 32 in the new law. All these things have really made the new Competition Act, coupled with the rule of reason, an opportunity for economists like you, Vishwanath, and your students who can help us in giving safe harbor arguments under the new competition law, that this is an effect which must not be overlooked by an authority. Abuse of dominance in the Competition Act is not per se illegal. Even, even as a lawyer, I would say cartel is not per se illegal in Indian Competition Act. It has a higher degree of presumption of appreciable adverse effect, where a respondent who is alleged to be involved in a cartel has a right to rebut. And that rebuttal, at times, we have seen many cases even started off with a leniency application. CCI found that the conduct may not have really outweighed the benefits the market has achieved. So the rule of reason is definitely part of the Competition Act, which is not, of course, there in the MRTP Act. The appellate tribunal in the Competition Act, of course, it has been now merged with NCLAT, is the specialized appellate tribunal, which we did not have in the MRTP Act. And in such a scenario, the last leg of the appeal before the Honorable Supreme Court is only relatable to points of law. And that actually, in my view, as a practicing lawyer, lessens the burden of the Supreme Court only relatable to, because it already had two filters. One is the filter of the CCI and the other was the NCLAT. So it definitely can reduce the waiting period for getting a finality. I stop here. I'll be happy to answer questions.
Thank you, Manas. That's a very comprehensive history on how the transition was. I mean, I think I kind of particularly caught on to this idea that you said, per se illegal to rule of reason. Rule of reason becomes, once again, I think just as Dhanendraji mentioned, um, pragmatism always needs to take a front seat in some sense, I guess, and that's where I would interpret from MRTP to CCI transition to be pragmatic while making sure that the markets function in the way they ought to function. Maybe that's how I would weave in the conversation that both of you have had with me till now. Pranjal, let me talk to you here. Maybe let me bring you into the discussion. You've been practicing competition law for a while, litigation in this area. You've been advising clients. You've been looking at so many of these, and you've been looking at CCI for a while now. So maybe if you were to kind of sketch the capacity augmentation within CCI over the last few years in your opinion, Pranjal, I mean, I think that would probably set the context going. I mean, we've heard these two gentlemen mention this move towards pragmatism, this new move towards looking at competition holistically in conjunction with the larger aim of country at the forefront, consumer at the forefront, competition at the forefront, etc., etc. Manas has also talked about how certain things are rigid in MRTP, but
Yeah.
rigidness used to fluidity requires changes. And I think I want you to reflect on the changes that you saw in the CCI over the years that you've been associated with this organization. Over to you, Pranjal.
Sure, sure. Thanks, Professor Pingali, and it's wonderful to be part of such a stellar panel here. So the question that you put to me on my experience as a practitioner on how we saw CCI emerging as an agile sort of a regulator in this new space. So from a practitioner's perspective, obviously CCI had its shares of obstacles early on, and so is expected of any new regulator, especially with such wide ramifications, with such sanction powers. And CCI was no exception to that, and we saw some early early on there were cases on violation of principles of natural justice, due process issues. So somewhere in between all of it, the cases were not really taken up so much when they were moving to appellate stage or writ petitions in various high courts. They were not really focused on the merits of cases. Rather, they were very focused on certain due process issues and for quite a bit. A lot of these cases did not receive the intellectual attention on merits, and that changed fairly quickly. And for that, Commission needs to be commended. With time, Commission showed its agility. They understood the problems, they rectified it, and we started looking at a lot of cases coming through on variety of issues. CCI looked at a variety of sectors, and traditional and non-traditional both. So we had steel, cement, glass, and asbestos, and real estate. So a variety of sectors on the traditional side, and then CCI slowly picked on the other trajectory of non-traditional markets, digital markets, surprisingly very early on as well. And the first Google case, for example, stemmed right back in 2012. So from that perspective, CCI has been at the forefront of looking at a variety of issues and very cutting edge issues from very early on. And some of the decisions on merits, we have seen how over the years stance on various issues have also evolved from CCI's perspective. If we come to the topic itself, digital markets, we've seen how CCI has evolved its views on digital markets from early days to a position now. And while in early days, and rightly so at that time, while digital markets were still fledgling and it was coming up, we saw that CCI taking a very pragmatic, innovator friendly approach, where they simply found that e-commerce or digital markets are merely a different channel of supply of products and services as an alternative to the traditional means. And therefore, they were not looking at digital markets as separate markets at all early on. And we had those, SanDisk and Mohit Manglani and CAF, those kind of cases early on, where, CCI was quite happy to be innovator friendly, so to say, and come up with a view which would enhance growth of digital markets, and that was the right call that was taken then. And even with respect to some of the factors, for example, there was a case against Meta early on, WhatsApp, in 2017, and at that point, I was just going through that order some time back, and it just reflects the how practical CCI has been in looking at these issues. At that moment, CCI in fact looked at how there are other apps, there are other competitors which allow multi-homing, and these markets at that stage were still evolving, and CCI was not particularly persuaded that there's network effects related problems in the market as yet at that point of time, even though in terms of the sheer numbers of users that WhatsApp had at that time, it could have been very easily held to be a dominant position. In fact, CCI did hold them to be in dominant position, but it stopped short of finding any abuse, saying that these markets are still evolving, and the effects like network effects, it's too early to sort of comment on those issues. And then we see how that trajectory has changed, COVID and post-COVID world, when we've seen such huge movement of e-commerce and general transactions on the online side. So overall, from a practitioner's perspective, I would say CCI has been very agile, and we have seen its growth, and we have seen how it has sort of traversed through the same issues in different ways at different point of time, and quite pragmatically. So it's a curve which is still on, and we will see it evolve further with time. But yeah, it's always you are never sort of resting on your laurels really as competition practitioner, and things keep on evolving, and that really keeps things interesting.
Thanks, Pranjal. I mean, even curve is never going to be flattened. Maybe the curvature is going to diminish over time, but the curve will never flatten, I guess. At moments like this, I mean, between the three of them, they've covered a huge swathe about evolution of this entity called CCI and how it worked out. And at moments like this, my role, I feel grateful about the fact that my role is that of a moderator and not a contributor. All I need to do is therefore intelligently nod at everything that these gentlemen say, absorb all the knowledge, and maybe make a witty comment here or there. But that's pretty much it. There is no burden of knowledge on me. But now let me actually come to that to the main theme of discussion, the digital competition bill. So my co-authors and I have been doing a lot of work in this area where we've spoken to a lot of startups. We've closely, roughly around 1,500 startups have responded to our survey, and we've had very close interactions, one-on-one interviews with several startups over the last few years, if you will, right? I mean, this is a project that started. The question is, how do small and medium enterprises make use of digital platforms? Now, there are a few things that I see digital platforms that bring to the table as far as the Indian consumers are concerned. One, of course, when you talk about digital markets, you think platforms, you think about reduction of transaction costs. I'm in Gujarat. I want to buy something from Arunachal Pradesh. Of course, physically meeting and exchanging is not possible. Digital world reduces the transaction cost. But here is a big thing, according to me, that digital markets do. And this leads to the improvement of small and medium enterprises. They actually build an element of trust among businesses. So, for instance, I order something from Arunachal Pradesh once again, and what I get is a box of trash, right? I now know I can call up the platform and tell the platform which is holding my money in escrow. And unless I actually confirm the fact that I have received the product in good and fair condition, the buyer is never going to get. So, therefore, the element of trust in the market increases, and thereby it leads to a lower possibility of market failures. Right? The idea of markets itself increases. Today, when you look at e-marketplaces by the government, gem portals and all that stuff, you know that the paper in IIM Ahmedabad is not necessarily supplied by a local vendor in Ahmedabad. It is probably even coming all the way from Bhadrachalam paper mills in Telangana. So these are this is the reason where you see there is a fillip to the small and medium enterprises and all that stuff. And I think if we go by the theme that evolved so far in the discussion, which is pragmatism, I would assume that this digital competition bill, in whichever form or shape it takes, will continue to pursue this idea of pragmatism, keeping in mind India's needs of making small and medium businesses flourish like crazy. Be it data law, be it network effects, be it inculcation of trust in the marketplace, etc., etc. I think the digital markets have a phenomenal role to play in the development of small and medium enterprises. Even my survey shows that the small and medium enterprises that rely on digital markets more and more serve more geographies. I've been making this joke in several conversations that I've been having as a kid who was brought up in 1980s Hindi movies. When I think about export market, I think about a closed room with four gentlemen sitting with gold rings on their fingers, doing shenanigans between themselves. Today, that's not the case. Everyone says I can do an export. I know I can rely on a platform's export market, and I rely on a different platform's advertising capabilities, and I can actually put my product in the hands of people who don't live in this country in the first place. I have gotten access to markets. This is the pragmatism. This is the ideal that we need to cherish in terms of fostering as far as digital markets is concerned. With this brief introduction in mind about what platforms typically bring to the economy at large, let me ask Manas a little bit. What are your views on the efficiency of separate inquiry framework in the case of digital competition bill in India that is going to be enacted soon? How will it be in comparison with the existing framework? Manas, if you could get into the nitty-gritties of the digital competition bill in terms of especially the inquiry and how it has been and how the digital competition looks at it. Maybe the pertinent question to you is, can we preserve the pragmatism that we're talking about?
Thanks, Vishwanath. The whole idea behind Competition Act and now the Digital Competition Bill is to have an expeditious disposal of anything which has been alleged to be in breach of the law. So, essence of the laws and the already existing enactment is to expeditious disposal of the dispute, because it's an economic legislation. If it is getting entangled into some kind of a litigation loop, then the whole purpose of the original complaint versus the final outcome becomes redundant. So the Digital Competition Bill also aims at expeditious disposal of abuse of dominance relatable to unilateral conduct of the big tech companies. So I would call this as a subset of the abuse of dominance in the traditional Competition Act. Because in the Competition Act, as we have so far seen, and Mr. Dhanendra Kumar also said, that dominance per se was not frowned upon was frowned upon in the MRTP Act, but not so in the Competition Act. That has been now taken to the next level in the Digital Competition Bill. Fine, but then we would like to dispose it off expeditiously, and in such achievement to be obtained, how do I do it? So the whole world is thinking in terms of ex ante regulatory regime rather than ex post facto. So between ex ante and ex post facto, as a lawyer, how do I look at it? Because in case of an ex post facto, in law and in legal terms, it means that the contravention has been allegedly been already made by one of the players in the market, and now somebody is affected by that breach, and that person brings it to the notice of the commission for an investigation oblique a final order. Now, this takes its own time because, in a ex post facto scenario of an investigation and following the principles of natural justice, that you give the copies to the parties, they should give the references and the responses, then there is a hearing, then post hearing you file a written submissions of your oral arguments. All of this takes 2 to 3 years in a very normal circumstances. How do I mitigate the limitation of this waiting period only relatable to digital abuse of dominance? So the Digital Competition Bill, to my mind, is a subset of the Competition Act, only relatable to abuse of dominance in the digital market. The Digital Competition Bill, as on today, as it stands, it does not really talk about cartels, bid riggings, merger control. It does not talk about. It only talks about how unilateral behavior of a big tech company by way of a gatekeeper, which in our bill it is called SSDE, is going to cause barriers to entry. So these barriers to entry is one of the fundamental principles of antitrust, and that is what is being addressed in the competition bill. However, your question as to how the difference between the inquiry and the investigation will happen, there, I have, since, Pranjal has very well articulated as to how the CCI has changed gears with the passage of time, how they have been supporting the innovators, how they have come to a stage where they initially faced a lot of writ petitions. Now even the Supreme Court finds that the jurisdiction of CCI is unquestionable, which clearly shows that the law and the implementation of the law are moving in the right direction. Keeping that in mind, and since the Supreme Court judgments are binding on all inferior courts, including the CCI, this Digital Competition Bill is the next level of proficiency which the CCI will have to really firm up and show to the world that we are here, we are arrived, we are there. So in doing that, the difference in ex ante is the risk. In an ex ante, there has to be a guard rail required. With the CCI's Competition Act getting dovetailed into the DCB, that is the Digital Competition Bill, the Competition Act has the enabling provision of suo motu inquiry by the CCI. Now, this suo motu inquiry has to be very reasonably exercised in an ex ante regime. Because in an ex ante regime, if you are exercising suo motu very rampantly and you are landing up with some kind of a divergent as to what you wanted initially to really remedy or discipline a big tech company, you failed. It will immediately impact the credibility of the authority. And there may be some reversal in the appeal, and that will really not appreciated by the stakeholders. That is the challenge which I think the investigator and inquiring authority must be very carefully try to achieve. And in the process, the domain knowledge in case of Digital Competition Bill will necessarily have the mix of technological experts, the microeconomists, the lawyers, the data experts. All of these people will have to be part of the competition commission and the DG competition commission. or the digital markets unit of the Competition Commission so that they minimize the risk of setting aside their order in appeal. I remember in the initial years when I was in CCI, and our first member, Mr. Vinod Dhal, he was very instrumental in bringing all great experts of the world. And one of the experts, Professor Alan Fels, the chairman of the Australian Competition Commission, he said, the best competition advocacy is that your appellate tribunal does not set aside your orders. So if we can achieve that in the Digital Competition Act 2, I think we will be definitely setting a great example that despite entire world is talking about DMA, ex ante, disciplining, taming, big tech, the CCI takes a path which goes along with our economic policy, the requirement of our MSME, requirements of our stakeholders, the consumer welfare, and end of the day, we are also able to rectify the market failure which may arise from the digital competition bill. The only answer to the difference between the inquiry and investigation, because end of the day, even for the digital competition bill, however it may be ex ante, the rule of reason would be the cardinal principle in adopting the investigation. What do we mean by rule of reason? Opportunity of being heard is given to anybody who is a party into the process of litigation, and the CCI should not be judged in its own cause. These are the two cardinal principles of natural justice. If those are being very meticulously adopted, I don't foresee any problem with regard to the digital competition bill. And that is what is my take, that with that limitation of domain knowledge experts investigating the matter, the things would be very well controlled insofar as ex ante versus ex post fact. I
Okay.
stop here.
Yeah. Thanks, Manas. I actually have a slightly different perspective and I'd like to put it forward. Our understanding on how the digital markets work and how the competition between various platforms will emerge is still emerging. I mean, in every sense of the word. At one point in time, we thought network effects are the be all and end all of the dominance, and today we don't agree to that particular statement. Many of us actually thought that small platforms don't have a space. Empirically, we're proven wrong in every sense of the word. So, therefore, I actually do believe that this digital competition bill also will have to evolve. The rules that with which it works today are not necessarily the rules that are in play in a few days from now. That's my reading of the situation. Firms
So
are
one
adopting to regulation, regulation is adopting to firms. So the equilibrium at some point in time will arrive. I don't know if it has arrived yet. Manas, you wanted to
So
comment.
only one point I would like to add, because whenever I speak more as a lawyer than as a practicing lawyer than as a theoretician. What I think is that you imagine a situation that a digital competition enterprise is being investigated by the CCI under the new act. What does the CCI will have to do from day zero? It must find that there is within the framework of the act all the paraphernalia and the procedures have been adopted correctly. How does that procedure would come? From the regulations which would enable the CCI to start the process of implementing the law. So while we are drafting the regulations under the Digital Competition Bill, it should remain within the confines of the Digital Competition Act. And since the CCI will be wearing two hats, one is the Competition Commission hat and one is the Digital Competition hat, it will have to synchronize the two, harmonize it in such a manner so that the ambiguity between the implementation of the two laws will not emerge so palpable that anyone goes to the appellate tribunal and start agitating that no, CCI made a mistake here, there, and that's the way they are trying to ventilate their grievances.
ठीक है.
It is the authority who has to really make good within the confines of the act so that the minimum opportunities are available to the parties in the situation of an appeal. So that is what I think would make the investigation between the two laws a little different.
Pranjal, you know, you had assisted Mr. Hagriv Khetan in, drafting the CDCL, and you're a part of the digital competition law committee that the CCI has called, and Ministry of Corporate Affairs is called. So many things. You've been very instrumental. We've been talking so far about the emerging knowledge of the digital markets with each passing day. That essentially means that certain fluidity has to be built into DCB to understand how the things are changing and how it adapts itself. I mean, it's an adaptive regulation as much as a regulation itself, right? I mean, so therefore, what are your views on a separate framework for regulating digital competition in the first place, and second, the building up of the fluidity within the law to help out things? I mean, rule of reason is something that Manas has mentioned. Anything else that comes to your mind, if you'd like to?
Sure. Oh, thanks, Professor. There. So yes, as you know, I was fortunate enough to attend almost all of the CDCL meetings, and in fact, CDCL went about its task very meticulously. There were subgroups, each subgroup looking at and focusing on a specific aspect before all of them sat together to actually drafting the report and coming up with the draft of the legislation. uh, so one of the important limbs of the entire exercise was to look at the existing framework and see whether we need a separate framework or not, and that was an exercise in itself. And for that, a lot of sort of empirical studies were conducted, looked at, and we looked at evolution of digital cases before the commission in the past, how other jurisdictions have been reacting to things. And I think one of the primary factors that was considered by the committee was the sheer timelines involved in dealing with digital competition issue. The fact of the matter is that any competition case will have to go through its entire set of rigmarole, and you will have a pre-prima facie stage, then you will form a prima facie opinion, then case goes for investigation. There the parties provide data at some stage, they may be put through examination, there could be cross examinations, then the report goes to the CCI, potentially it goes back for reinvestigation, then again final order comes. And by the time we go through all of that process, we lose massive amount of time, which is of essence, especially in digital markets. I think that was the primary concern there, that even from the stand, so this all stemmed from the standing committee on finance, the parliamentary standing committee on finance, where they raise concerns about how the digital markets have a tendency to tip in favor of one large incumbent, and how it creates sort of barriers, etc. So even if an investigation is uh, initiated in the traditional regime, by the time you come up with an order, even addressing those issues, perhaps the entities have really moved on since that time. And that was one of the areas that the committee looked at very carefully. They looked at a lot of data from different cases, the timelines involved in different cases, and we need not forget that even at the appellate stage, the life cycle of the case will have its own sort of journey. So from all of that perspective, it was thought, and in my view, rightly so, that there has to be some mechanism of tackling it in a different way. Although it can be debated what is the right mechanism, but quicker identification and regulation of certain conduct, that is surely needed in the current environment. And I think there was a sort of unanimity that there is that need, that issues should be identified quickly and addressed, whatever be the mechanism. So that was sort of the starting point. And at that stage, obviously, we're looking at, a great deal. There was a lot of work going on in EU, and even in certain other jurisdictions, and there, a comparison was made, looking at different models and what should be the most effective model for regulation. And it was felt that certain entities must be identified based on certain objective parameters, and only those entities should be subject to this kind of very targeted and targeted regulation. So from that perspective, then things moved on. What should be the right sort of thresholds? And obviously, it's all out in the open. The committee has just come up with its suggestion on thresholds, and they might just change over a period of time after deliberation. There has been a lot of deliberation on the right thresholds, etc. But largely, I think there is, at least within the committee, there was consensus that there needs to be targeted, identification of issues which would allow the regulator to move quickly. So, what does this kind of new framework uh, do is it allows the commission to sort of bypass some of the procedures that you would traditionally see in the competition acts. For example, defining market itself could be a massive exercise. In every competition case you bring out in the existing competition act, you need to define market. It needs to be well tested, it needs to be cohesive, it needs to stand scrutiny of courts. Then you need to find market power or dominant position in such market, and then comes the question of finding abuse within the four corners of the law. I think that entire process is just too long in the current scheme. What a framework like the DCB does is that it does away with the requirement of defining market, finding a dominant position. I think these two are sought to be based on persistently strong financial strength and user spread, as the committee calls it, the twin tests that any entity must meet to be within the framework of the DCB. So if these two criteria are met, then CCI would not have to go through that entire process of defining markets and then finding market power. And then comes the question of conduct itself. And on conduct, again, the idea of the law is to, lay out few specific conduct which are sort of, very specific to each entity, to each entity's core digital service, and only those specific conduct need to be regulated and need to be is in the watch out zone for those entities. So in that sense, the DCB tries to keep it very targeted, sort of lean and mean machine in that sense. But obviously, there could be alternatives. We have looked at other jurisdictions where to start off, they suggest a softer approach, a soft lock kind of approach. For example, if you look at Japan, they are sort of leaning more towards self-regulation at this stage, because legislation of this nature is not well tested anywhere in the world. Even if you look at EU, we have had
Things are still emerging on how effective it is or what the bad things about it are, good things about it are.
Exactly, and even on the effects on the market, there are sort of
Yep.
always views coming in that as a result of the obligations, rigid obligations that they have, you looking at probably less number of small and micro enterprises, smaller entities showing up on say Google searches now, because you can't use third party data, you can't use a lot of your data to sort of give users the best information that is available. So all of that is still being tested. So yeah, it's a good thing that we are debating all of this at this stage before we actually have a law in hand.
Beautiful. I think the evidence from Europe, as we know, is still emerging on its impact on small and medium enterprises.
Yeah.
It's still emerging in terms of, the innovative capabilities of European companies. There's a paper that came out recently in academic journal which talked about how number of patents that are being filed by the European companies is going down, number of products are going down. So therefore, the evidence on how the digital markets themselves are evolving is changing every moment, right? I mean, how do you define competition How do you account for contestability? I mean, these are some of the prime questions that are still coming through, and I think the digital competition bill has to, walk a thin line between pragmatism to the small and medium enterprises, which is what my next question would be on, and not creating policy uncertainty because it is vague in its nature. And I think that's the challenge that I foresee in the writing up of the DCB in whichever format that it will emerge. Dharendraji, let me bring you into the conversation here. You've heard both these gentlemen talk about how the bill has evolved and how, what are the various issues. I want your views on how. Again, I'll pin you down on the word pragmatism, sir, that you so easily conceded to me at the beginning of the talk itself. If I were to define pragmatism as sustainability of small and medium enterprises in the Indian context, let's be clear, these are the enterprises that are driving India in every sense of the word. The startup ecosystem. How do you think you see this digital market come through? How do you see the views of CCI emerging in it? Will new mechanisms that both Pranjal and Manas were talking about, will they address the startup communities, space in the space currently entrenched by the big tech? Your views, please, sir.
Thank you, Dr. Vishwanath. A very important question you have raised, and I'll
I'm
be
sure
happy
we've
to.
had several private conversations, sir, on this matter. One or two we've had very interesting
Absolutely.
conversations.
Uh,
Maybe we
let
could.
let me attempt some answer to it. As I said in the beginning, every country, every jurisdiction has to go by its own economy, the benefits involved in this case. Now, India is world's largest populated nation at the moment, and the profile of India, with its 140 crore people, almost two-thirds of the population is relatively young. Many of them are in startup or near startup space. They are planning to put up their own small micro industry units. We are one of the world's largest startup ecosystems in the world. Over 50,000 startups. Some people say now it is even 65,000 plus. And the government has built up its digital stack where the digital first ecosystem with inclusivity, innovation, and global competitiveness rolled out the digital infrastructure in a big way. Now, in such a scenario, it's important that our MSMEs they are benefited as much as possible through this kind of a regulatory ecosystem we are trying to evolve. Now we have to carefully see and calibrate it accordingly. As you very rightly pointed out, some of the experiences which we have seen, which we have heard in Europe, do not exactly point out to some of the benefits in innovation and many other things. Say, for example, in the case of Europe, the hotel industry, I recently had occasion to go through a study, Mirai.com, which said that after the DMA, there has been almost 30% drop in terms of clicks, direct clicks for bookings in the hotel industry. Now, that kind of a thing, for whatever reason, this was one of the instances which came to my mind. We have to see what will be the best thing to happen in India. Well, let us confess that the digital competition bill, in whatever name or shape or form it comes in India, it is certainly one of those things which is bound to come, because that is the global trend, and in any case, it would be useful for India's digital ecosystem. But question is when. Do we have enough experience of the jurisdictions where it has been practiced, where it has come? As we said, in Europe, we have seen what it has come. You yourself mentioned, and so has Pranjal. If we see the Indian SME ecosystem, there are many of the startups which are pretty big, like the Zomato, the Swiggy, the MakeMyTrip.com, and stuff like this. Now, many of these bigwigs, they might be hit in the same manner. I mean, it's not only the big tech which are going to be hit. In terms of the various filters, they could also be hit, and that probably may not be the intention of the digital market, the digital bill that we are trying to bring in. We have also to keep in mind, as Manas very rightly pointed out, that the digital competition bill is going to be a part of the digital competition law. Even now, the Competition Commission is looking into many cases in the digital space, and they have delivered judgments. Many of those judgments have been upheld. There is a digital market unit which has been created in the CCI, manned uh, by eminent experts, and we hope that they would be developing their capacity in handling the cases involved. Now, in this kind of a situation, whether we have come to a point where we need to have a separate legislation to deal with the digital enterprises, that is something which we have to see. Or should we also should we also wait for a little more time to see the experiences and get fuller advantage of the late mover advantage rather than the first mover advantage, and design calibrate our system to suit the needs of Indian economy. Some time ago, the industry representatives, including several startups, they met the Ministry of Electronics and IT, MeitY, and they represented to them what their concerns were about the digital market, digital competition law. And this was widely reported in the media at that time. And the government promised to look into it. Now, India has a different structure and the story and the aspirations than the rest of the world. So we have to ensure that the needs and the aspirations of our own MSMEs are kept in mind, particularly the digital enterprises. And these days, most of the sectors, you name any sector, and they ride on the digital platforms, and whether it is a health or whether it is education, whether it is defense or the delivery and so on. Now, by the way, one of the very relevant points which you yourself mentioned was about the payment ecosystem. That if you order something from, let's say, Nagaland or somewhere, and if you make payment through one of the established e-commerce entities and so on, then you have the trust, and you would possibly go ahead with the payment gateways. India is one of the most advanced payment gateways, the moment the UPI systems and so on. So altogether, we have to see whether in this kind of a situation, we are right to have a digital market act as mentioned in the various provisions of the digital market bill. We have also to see whether some of the abuses which have been mentioned in the proposed digital market bill, self-preferencing, for example, or manipulation and things of this kind, can be handled by the existing competition law in some way or the other, rather than having a full-fledged separate legislation for this. So I would say that we have to look at the digital competition bill a little more carefully, taking into account the needs of the Indian economy and Indian startup ecosystem, what will be the best for them, to consider their growth. And also keep in mind that India, of course, is not only the world's largest populated nation, but also the world's fastest growing economy. And in spite of the slight blip in the drop in the GDP in the last quarter, which was 5.4%, still remains the fastest growing. But we have to maintain the rate of growth uh, as fast as possible in order to reach the level of Viksit Bharat that we have. And in this kind of a scenario, we have to be careful whether any digital bill of this kind would be in conformity with our needs of our march towards Viksit Bharat. So altogether, I would say that yes, we have to see and assess the benefit. We don't have adequate data at the moment with us to see what will be the impact on the startup ecosystem of the proposed digital bill, but we can only see it from the experiences from the existing jurisdictions like EU and UK and so on. So we have to keep that in mind. Thank you.
Thank you, sir. Thank you very much. But I'm going to push you a little bit more. What do you think are the expectations from the policymaker and the CCI with the
Naresh?
Digital Competition Act?
Well, the policy makers, I would say they are very keen that our startup ecosystem and our digital enterprises, they are giving as much push as possible. And the digital stack, the government, the digital stack has been designed accordingly, and throughout the length and breadth of the country and the entire the rural areas, the hilly areas, the tribal areas, and so on, the digital infrastructure has been spread. And
Mm.
the government's policy in terms of pushing the digital economy into the hinterland of the country, I would say, is designed accordingly. And that's why, in my own view, uh, some of the advantages which India can derive from the structure and the from the kind of population it has, from the kind of innovation it has, would be through the e-commerce and through the other benefits, the low-hanging fruits of the Indian digital economy, which needs to be fully exploited the moment. And I'm not against big tech per se, but I'm only saying that let us decide when do we need to have the digital bill of the kind that we have in mind.
Great. Thank you. Thanks for that answer. I'd like to come to the next set of questions here. But before that, I think a couple of remarks would be appropriate. Um, the digital competition bill, let's be clear, digital is everywhere, right from telecom sector to insurance sector to financial sector to pretty much any sector you talk about, mining sector, technology. I mean, technology is everywhere. It's ubiquitous by its presence. And not just technology, digital technology per se is present pretty much everywhere. Now, the problem is, while you have a competition commission of India that is good at regulating the competition, you have the sectoral regulators too, who are also looking at this problem. So, for example, issues between the banks, SBI, SEBI plays a huge, in terms of the financial institutions, SEBI plays a huge role. In terms of insurance sector, IRDAI plays a huge role. In terms of telecom, TRAI and DOT have their own roles in terms of how they expect the markets to evolve. So I think I am scared. As an economist, I'll put my fears in front of the three eminent panelists here. Uh, is it possible that, and I'll ask specific questions after that, is it possible that there is a clash between the way a competition law envisages the way the sector needs to be regulated and the sectoral regulator, looks at this? What it generates is what I call as policy uncertainty. What are the problems with policy uncertainty for a business? I mean, in my interviews of various businesses, I've come across this very interesting thing. Even if it's a bad policy, I know how to live with it. But if you don't tell me what the policy is, I don't know how to live with it. So, in other words, policy uncertainty has a dampening effect on businesses because simply businesses can't forecast what they want to do on, going forward. I'm a great proponent of the fact that if business turns into short-run optimizer, if the long run of a business turns out to be a series of short-run optimizations, the business's sustainability will always be at stake. Now, the problem with policy uncertainty is precisely this. So that it converts a long run time horizon into series of short run optimizations, and that essentially means that the progress is not as fast as you want it to be. Now, Dhanindraji kept on is telling us about how competition law has to dovetail with the idea of Viksit Bharat and the development of the country. So, therefore, to me, the policy uncertainty in the amalgamation of various regulatory bodies is a danger that we need to be worried about. So this is where my next set of questions come up. Pranjal, is there a potential risk of multiple proceedings for competition violations? Can jurisdictional battles come up between regulators the way you see it? Since you're one of the people who are involved in actively drafting it, maybe you can tell us what is it that you're
Yeah.
looking at sectoral safeguards.
Yeah, sure, sure. That's a very important point. And, as lawyers, I think the first thing that lawyers do whenever a case comes up on competition issues is to see whether CCI's jurisdiction itself could be challenged one way or the other. And there will always be issues of jurisdiction, especially in the digital sector. And we saw this as late as the Meta order that came just a couple of weeks back. And Meta very vehemently argued, and obviously the issues are still open, but it very vehemently argued that data, it's the issue of data protection. There is a whole spectrum of litigation relating to WhatsApp's privacy policy separately. So it should not be CCI should not be the body who should engage itself looking at privacy issues. uh, and CCI obviously sort of took a view that as long as it involves competition harm, even if it is sort of a issue germane in privacy or elsewhere, as long as that leads to competition harm, competition commission as a body will have the power. And all of that sort of also stems from how various legislations are drafted, right? And we're working, Manas and I were working on a case together, and we see that all the legislation, different sectoral legislations, have a non-derogation clause which says that this law is in addition to and not in derogation of any other law in the time being in force. And at the same time, it also states that the Competition Act is an authority on the issues of competition, and no other legislation shall take precedence. So, and other legislation similarly has those kind of provisions as well. And therefore, we will always see these kind of issues emerging from time to time. And I think it's time that we took the next leap forward in addressing jurisdictional issues. I think for the longest time, we have seen even in the Competition Act cases over the years, the Cellular Operators Association of India's case, the issue between TRAI and CCI, and there have been plethora of cases involving different regulators, and it always sort of goes to court then to decide which should be the appropriate body. And I think it's now time that we should have an inter-regulator sort of a forum. And this is an idea, which is not coming out of the blue, and we see already some jurisdictions having these kind of mechanism. For example, I see in the UK there is Digital Regulation Cooperation Forum that has been created as a joint forum for 3-4 regulators in the digital space. The CMA, the Office of Communication, Financial Conduct Authority, and one other organization. And they sit together, they decide the agenda, and they very clearly decide amongst themselves which are the cases that they will pursue. Amongst the regulator, there is a unanimity which regulator should go ahead with a particular issue, and I think that can solve for a lot of issues that we see. You cannot look at legislation and the court route to sort of settle the jurisdictional aspects. I mean, even if you look at FTC and DOJ, how they function
Yeah,
parallelly
sure.
in the US, so they also have a mechanism where both of them sit together and decide the cases that they will pick up. Uh, one foregoes the case for the other. They have this clearance process that they call it. So that has been very handy in sort of dividing the course between FTC and DOJ. There's no reason that we can't move to that stage of inter-regulatory sort of deliberation and understanding on how
Let,
each digital issue might be addressed.
let me
Yeah.
stop you there, and I want to bring Dhanindraji into discussion. He has had experience working across various sectors. I'm sure we all agree. He's been with Ministry of Defense, he's been with several other ministries and several departments. So, do you really think we're talking about a theoretical debate out here, or do you actually foresee that between the sectors there is going to be a clash between the regulators? And Pranjal has raised a very interesting argument of regulating the regulators through a overarching regulatory body that acts as a quasi-judicial in terms of telling which regulator wins over which other regulator. How do you actually foresee this conflict? I mean, you probably are a neutral body just by the fact that you've worked on so many departments.
Dr. Vishwanath, I fully agree with what Pranjal mentioned. In fact, in 2012, I was heading a committee which had a number of lawyers. In fact, Manas was a member there, and most of the law firms in India were members to draft a national competition policy. And then within that draft, which we evolved and we sent it to the government, it is still lying on the website of the Ministry of Corporate Affairs. We suggested exactly the same thing which Pranjal mentioned about UK, that let there be a coordinating mechanism among various regulators. And I think the need is even more pressing today because in the digital economy, most of the sectors now they ride on digital platform, which you just now mentioned yourself. I don't expect in India there would be too much of a problem. In one case, in the Bharti Airtel case, for example, the Supreme Court held the jurisdiction of CCI because they are the expert body to judge the competition dynamics in the market. But on various other matters, the immediate specific matters which are core to the sector concerned, it should be the sectoral bodies, sectoral regulators, which should go into it. So there could be some understanding that these are the areas, these are the spheres in which you will work, these are the spheres in which CCI will work. CCI, which is the regulator of the regulators, or when there could be ego clashes and so on. But the fact is that whoever is equipped to handle something in the best possible manner should do it. If it is market competition, CCI does it. If it is in TRI, for example, they would be best equipped to look into the specifics of the telecom sector. And by the way, I worked in the Ministry of Telecom also. It was mentioned by Manas in the beginning. So in many areas, one can see that they are the people who are better equipped. Try, for example, they are a pension regulator or the financial markets and financial regulators and so on. But the market, whether the impact on the market is positive or negative, or the competition and so on, this is the CCI. So we'll have to decide it accordingly. Whoever is best equipped in terms of expertise should do it. But how to do it? Uh, One possibility could be what Pranjal mentioned in UK, and this is exactly we had recommended in my draft of national competition policy in 2012. So we can decide in due course of time what should be the model appropriate for India.
Great. It's Manas, I'm going to give you a very unenviable task out here. I'm going to give you a very broad topic, but I'm going to give you a very limited time, simply because we're running out of time. Any final thoughts on DMA versus DCB? You know the research
So,
that's happening in the economics and management side as
sure.
well. You've been friends with several people, both in EU as well as in the FTC, and you know that there are people who are very critical of what people are talking about as far as DMA is concerned. There are parallels between DMA and DCB, some parallels, if not a whole lot. Your final thoughts on DMA versus DCB, and honestly, you have 3 minutes, I guess, to do the
Yeah.
unenviable job. Go for it.
Anyways, I'll just very briefly share my personal thought. It should not be considered to be a thought of anyone who has been associated with the digital competition bill. I have always been holding one view that EU is a conglomerate of 27 independent sovereign jurisdictions, and each sovereign jurisdiction has their own competition law, their own competition problems, their own digital competition problems, yet they have DMA. So this DMA is relatable to implementation of the digital competition issues within the ECM, that is the European Common Market. But if it comes to, say, for example, Germany may not have exactly the DMA, but it will be almost having something which would a mix of their German economic realities versus the European economic realities. Similarly, we have to also see, say, for example, UK is not accepting the DMA model. Same is the Asian jurisdictions. If I do not specifically name any Asian jurisdiction, but the Asian jurisdictions are very mindful of the fact that the DMA may not work in their jurisdiction. They would be more interested in looking after the consumer welfare aspect, the data privacy aspect. Of course, these are all emanating from the same digital space, but they would not be mimicking the DMA as such. And in fact, if you ask me honestly, I have not so far seen any sovereign jurisdiction has adopted DMA almost a mirror image. They all have their own economic realities as the priority and then try to ensure that best of the DMAs may come within their framework of the digital competition law. With that, I think the DMA versus DCB also, why it is generally perceived to be almost an identical mirror image of DMA. But when ultimately the law gets the nod of the parliament and the final assent of the president, I'm quite sure, it's my personal view, that DCB would be very different from DMA. It cannot be almost identical to DMA because there would be lot of issues which needs to be thrashed. And as we see in the newspapers almost daily, that there are certain sectors who are very skeptical about DMA being adopted in India. And
I'll
those
just tell you
sectors
a
are very,
small example here. I was teaching a class with exchange students in it with our own students, and the issue of privacy laws came up into the picture. I think the class couldn't have been more dichotomous than what I've seen. Our kids are like, I mean, there is this European kids who say, my spouse also doesn't know what my salary is, and I think it's a private matter. And here is our kids who are telling us, of course, my aunt also knows, my chachi ji also knows, and my masi ji also knows how much I make. So therefore, it's a very interesting idea of what privacy is across all the countries itself.
absolutely. And the final thing which I would like to share with you is that as an Indian independent sovereign jurisdiction, the challenge to the jurisdiction of the CCI by the big tech companies have all been settled. And the CCI does have the jurisdiction even under the existing Competition Act. The example is, as Pranjal said, Meta. Just about a couple of weeks back, the CCI comprehensively decided the matter, which is purely a digital matter. And they have done it within the existing traditional competition law. I am not becoming a kind of a person who is foreseeing what is going to happen in appeal or in the final appeal. I am not talking about that. But as a primary commission, which is likely to wear two hats down the line sometime soon with the DCB and the CCI, they still exercise their jurisdiction on the matter. And that is where, our law is comprehensive to even handle the digital competition bill. So that is an area which I think when the law gets finally the nod of the parliament and the president, will have a lot of gaps in between the DMA and the Indian DCB.
Thank you. I think the clock says exactly 48 seconds remaining as I speak. So
Let me
therefore,
just mention one or two things here. Since both Pranjal and Manas mentioned about Meta's case and then it settles and so on, I believe it is still under appeal. So we cannot say that this is the final word on this subject. So that is one. And the second thing which I wanted to share, which I did mention in some other way in the beginning, that we have to have a balanced approach. In India, there should not be an over-regulation. There should not be, we have to make sure that the regulation is optimized to ensure that it leads to uh, optimal innovation. So it has to be specific to India. This is something which I wanted to add from my side in the end.
Thank you. I think we've
Rishi, I
listened.
think we cannot take questions because we have already,
Yeah, yeah, we
uh,
cannot take questions. So let me
but
maybe take
we
half
can
a minute.
definitely respond to all the people who have given their questions in the chat box. If we get their emails, we'll be able to answer on the
Yeah, yeah,
email subsequently.
sure. I think that the organizers will be able to pass on those comments to the three of you. I just quickly say this that again, my duty is to ask questions. What answers come are some things that I bother about. I don't bother too much about. My duty is to ask tough questions, and I think the three gentlemen, from what I understand, I can only be thankful for the fact that I'm not being subject to these questions. So, but I think one thing is clear to me as we wind up this discussion: the digital competition in India is up for exciting and interesting days in the coming times. So, therefore, I think we should be looking forward to how it shapes up and how, more importantly, it shapes up the Indian economy in the coming days. On that note, I think I'd like to take a moment to thank the three panelists for being patient with my questions and answering them to the best of their ability. Thank you, everybody.
Thanks.
Thank you.
Thank you very much indeed. It's been a pleasure, and I'm sure the audience, the participants, would have also enjoyed the conversation. I believe there was a very wide participation, and I thank them also for joining us today.
Thank
Thank you.
you.
Thank you,
Thank
Bye.
you.
Dr. Vishnu. Great job, the moderator.
Thank
Everyone
you.
have a good. Thank you.
Thank you.